Well, I don't know why I have to be brief when everybody else wasn't. Anyway, I'm with FMO. Typically I wear my FMO shirt, but today I thought it was more important to be Irish for my mother's sake. John asked me to talk to you about an initiative we're starting in FMO to revitalize and rebuild the legal fund. But there was a lot of things that were said today and I wanted to clarify and get some understanding. First, in a rental park where we own our homes and rent the ground that they sit on, we fall under Florida Statute 723. And I've heard some things about 723, but you got to remember, before 723, there was a Landlord-Tenant Act, Florida Statute 83. And if you read that, you realize you had many more rights under 723 than you ever had under the Landlord-Tenant Act. You have the right to form your homeowners association. You have the right to receive your prospectus. You have the right that, and I heard about getting prospectus approved and you don't even know about it. Well, the law says within 90 days of the approval of that prospectus, you have to be notified. Or any changes in the rules and regulations, you have to be notified. If that's not being done, then that is a legitimate complaint. I heard a lot of things about DPPR. We are frustrated, just as you are, many of you are, with DPPR. As a matter of fact, in our legislation for this year, we were unhappy with the language in 723 concerning DPPR's response to our complaints. And what it said was that they may provide feedback to you within 30 days, and they may provide further feedback within 90 days. Well, we were able to change that in this year's legislation to they shall get back to the person who made the complaint within 30 days, and they shall respond back the status of the investigation within 90 days. However, when you do make a complaint to DPPR, and it's about a specific park owner, then they do automatically tell the park owner that there's a complaint, because the first thing you want to do is try and get them to respond and hopefully take care of the issue rather than have to go any further with their investigation. But that, we all know that's not happening. We're continuing to chip away with that on the legislative side. And I've been involved with the legislation. I spent a lot of time myself going through 723 the past 3 years. As a matter of fact, about 3.5 years ago, I wrote up a new amendment to 723 that was going to create a new 723 and fix all the problems we had with 723. And I sent it to Senator Dieter in Sarasota, who sponsored it, and Representative Robinson in Charlotte County, where I live, which is a long way from here, who also sponsored it in the House. Well, that was the beginning of the 2015 session, or 2014 session. And there were about 6 other individuals from around the state who also did the same thing. And finally, the legislature came to us and said, look, we don't know exactly what FMO wants or what FMO stands for or what residents of these mobile home communities want. And so we want you to bring us a negotiated bill, or a bill that's not controversial, which kind of struck me funny because all the other controversial issues they handle, but mobile homes. So what they did was they forced us to negotiate with FMHA. And when we're negotiating with FMHA, we're still in an inferior bargaining position. Let's face it, they own the property, we own the houses. And that's always going to be the case. We're trying to chip away from that. We've learned a lot in the negotiations with them. We've developed, some kind of a relationship. And I had a similar park owner down in Dade County that was an off-site manager who hired a tyrant as a regional manager. And those people were having all kind of issues down there. The same thing. And what we find going around the state is that the people that own maybe 1, 2, 3 small park owners, whether in the state of Florida or not, are really the biggest abusers of the law and the biggest issue that we have. and most of them don't belong to FMHA. I went to FMHA about this guy in Dade County, and asked if they knew anybody, and they gave me one name, and I sent off a letter to them, and I did finally get a response, and a new regional manager came in and tried to work on some of the issues, but they're still having problems down there. The bottom line is, since we have to negotiate our bills, we don't really get everything that we want, and as a consequence, they don't get everything they want either. Maybe the first three things that either one of us want never gets into legislation, because that's what negotiations are, the outcome of negotiations. What happened in the past couple of years is that we've taken a look internally. What can we do to strengthen our homeowners association? Last year, we felt the number one issue was to train people to come onto the boards of homeowners associations so that they understand the law and they understand exactly what their rights are. And you should have a prospectus with your home, and you should have that prospectus should, by law, be passed on from owner to owner. Now, it's lost somewhere along the line. The park owner may issue another prospectus. What happens in my park? I'm part of ELS, and ELS is the largest park owner here in the state. And which is good and bad. It's good in the respect that they have a lot of eyes on them, so they don't abuse the law, but they're always in the gray area. They're always trying to find ways to squeeze a few more dollars out of us. And if you've got a strong HOA and you have the right to negotiate your HOA with a 5-member committee to negotiate with the park owner, and we've gone so far, ELS now, to have quarterly meetings and actually give some input on their capital expenses. But you don't get that kind of commitment at the kind of level that you're talking about with owners like Mr. Is that they either don't understand the law or they don't really care. What I've heard so many times is that their mantra is, if you don't like it, sue me. And give you a little history on FMO. We've been around since 1962. FMO was instrumental in getting 723 written in the first place. But it was written in 1984. And yeah, it does need changing. And we're working a way to change that. But as I said earlier, because we have to do it through negotiations and bring them a bill that isn't controversial, it's limited. We have our one hand target on our back, sort of. So that's one of the issues that we face. There are some legislators that are very strong, and make sure, in addition to trying to communicate to them your issues electronically, make sure that you invite your local legislators into the park. We've had some that have never even been inside a manufactured mobile home, and let them come into your park and understand. And we had one individual park owner down in Charlotte County. We were having the FMO meeting there. We invited the local legislator, Ken Robeson, to come and talk to the people. And he said he wasn't going to let us hold the meeting. Well, we said, well, we're having Representative Robeson come into the meeting, and all of a sudden, the doors are open and we have a problem. But make sure you engage your legislators, because it's important for them to understand. We have a lobbyist that we pay part-time in Tallahassee to do the fighting for us and to let us know anytime there's a mobile home bill being created, whether it affects us positive or negatively, so that we can respond to it. And typically, if it's something that we don't like, we will send out what we call a watchdog on your bulletin board over there, and also to let you know to write your legislators and tell them we don't want this particular piece of legislation passed. After you negotiate a piece of legislation, you have to get a sponsor in the House and the Senate. Then that legislation has to go through 3 committees, 3 in the House, 3 in the Senate. Each one of those committees has to pass it positively before it goes on to the next. And then it goes to the floor of each chamber and then finally to the governor. So anywhere along the process, a bill can be killed. And what's happened practically since 1984 is that they wanted to pass something that we didn't like. And so we wrote our legislators, and the bill was killed. It never went through one of the committees. And they did the same thing. We have the power of votes. I saw that maybe 60% of you are full-time residents. However, they got the power of money. And it's nothing for them to make a contribution to a political campaign or to a fundraiser for a committee chairman. And so those are the kind of things we have to deal with. And so the legislative process becomes very difficult for us to affect change. And back in 1962 and through the 70s and 80s and probably early 90s, FMO was approaching 100,000 members statewide. And at that time, legislators used to come to us and say, what can we do for you guys this year? How can we help you? Those things have changed, folks, because of the complacency in the past 20 years. Our membership is down to probably less than 20,000 now. And there's strength in numbers. There's also, by being membership, the membership dues that comes into the organization really goes back into what we can do for you. Back in those early days when we had a big fat legal fund, anybody that wanted to bring a lawsuit against a park owner, or bring a lawsuit period, FMO would give them money, say, here, go to it. And it got so bad, it was uncontrolled, it got so bad that we had an HOA board member who wanted to sue the board, and so we said, here's $5,000, go at it. And then we had the board come to FMO and say, we're being sued by one of our board members, we need some legal help. Here's $5,000. So we funded both sides of that particular issue. That's one of the horrible stories that happened in the past. And the simple fact of the matter today is we don't have a legal fund. Money is not there. We have enough money to pay our lobbyists, to have our attorney on retainer who guides us through the legislative process, and to maintain our monthly magazine. But beyond that, we don't have a lot of funds. About a year ago, the district president from District 1 down in Polk County said he would like to, within his county, start a legal fund, going to HOAs and ask them to make contributions to this legal fund. Well, I was part of the legislative committee, so I said, well, this is a great idea. I said, I think not only should we do it in Polk County, but we should do it statewide. So we put together a plan to present this to the board of directors, and every 2 years we have a meeting of delegates from FMO when we elect our officers and review our bylaws and make any changes if we felt necessary to do that. But at this meeting we just had this past December, we elected John Salvucci, who's been a great leader for our organization and kind of turned it around the past 2 years. And at the same time, we presented to the delegates the legal fund that we wanted to move forward on, and they unanimously agreed to support the effort. And what it is because we don't have the funding, we're depending on HOAs to participate in this. Once you're a member of the legal fund, then you have the right to bring a legal action and submit an application, or submit an application first, and for us to consider to support that legal action. And the intent of the fund is to support a legal action all the way through the process. And basically, what's going to happen when you create a legal action today is that you're going to start out in the civil court. And if you win there, in most cases, the opposing side, the park owner, is going to go to the appellate court because they're not going to stop there. And so we can almost guarantee that you're going to have to go through those two court systems to get a final decision. And what we're hoping is that at some point in time, there will be a precedential decision made which will affect 723 or affect whatever we're trying to do with the legal action. This, in order to form this legal fund, what we've done, we've created a standalone committee under FMO. And the reason we kept it under FMO instead of a separate corporation because there's a startup money involved in setting up a new corporation, and we didn't want to spend money coming into the fund to do that. So we formed a standing committee under the FMO. We have a separate bank account, or more than one bank account, set up to handle this fund, so the funds are all separated from what comes into FMO. And there's a 9-member committee that oversees the fund and oversees the whole program. And we wanted to diversify the committee so that we have 3 members of the board of directors on the committee, which one is our finance director for financial guidance. We have 3 HOA presidents, and we have 2 district presidents, and we have our legal counsel. So we feel we had a pretty cross-section of people representing you all and the FMO. And also we have financial experience, we have legal experience, we have another attorney that's an HOA president, retired attorney that's on the committee. Once the fund is built up to a level, and our objective is to try and get this fund up to about $500,000 in the next 2 to 5 years, because, as I said earlier, you're going to go through two court processes. We expect that the money for that is going to roughly be between $70,000 and $100,000 by the time you're through with the legal action. So we want to be very careful about the types of legal actions we take. We want to make sure that our case is winnable, and we want to monitor it along the process. But once we approve someone for this legal action, the fund is going to take care of funding the process all the way through. The HOA does not have to contribute anything further other than to be the one to bring the action. The FMO is not going to be a party to any of these actions, nor the committee. Only the person is bringing the action. And so it's essentially a grant to fund the legal action that we feel that is, in our judgment, is both necessary and winnable. And we're looking at legal actions that are going to affect, a number of people, either throughout the state or throughout the community or throughout maybe one particular park owner like Mr. Tamboro. I think we got to send some kind of a message to people like that as well. What we're looking for, and this is not for everybody. There are 2,700 parks under 723 according to DBPR, which is 2,700 parks with 26 homes or more. There's probably about 4,500 parks statewide, but if you take out the resident-owned and some of the others, then there are only about 1,700 parks. We're looking for an HOA to make a contribution, initial contribution of $1,000, and over the next 4 years to make a contribution of $500 per year. You can break it up in increments of $250. So the total commitment really is about $3,000. But again, you're part of the fund. You have the right to submit a legal action for consideration, and the fund is going to be a grant to you to pay the attorney to carry on the legal action. We're also, as part of the program, we're putting together a list of attorneys around the state who have represented people successfully in 723 type cases. And there we can use your help. If you know of anyone that you feel comfortable with and recommend, that we can vet and put on this list. We have a list now that's been created about 4 or 5 years ago, and we're working through to see if some of those people are still interested in taking on these types of cases. And once we have that list completed, it'll be available. But again, we're a little ways from supporting legislation or legal action to this point. But we started out just a month ago in Polk County, as I said earlier. We currently have 6 parks, 5 of them in Polk County, 1 in Sarasota County, who have become members of the fund. 2 of those parks have put the entire $3,000 contribution into the fund. The others are going to be on the payment plan. And the reason for this is, number one, we wanted to build the fund up quickly. And number two, there's a significant amount of money we want to have in the fund, because as I said, it's going to cost money to take on any type of legal action. And the fund is going to give the person who brings the legal action that we feel comfortable with to fund the entire action. So, and the only thing we would ask is that if you win your case and you get money awarded to your HOA as a result of that case, that you just return to the fund what they advance you, and anything else is the HOA to keep. Now that's basically how we like to see it work. On our website, FMO1.org, there's an icon on there that gives you more information on the fund. There's a slide presentation if you want to make it to your HOAs, or we're happy to go around and talk to the individual HOAs as well. And there's also a contract on there. Every HOA that wants to participate in the fund has to read and sign the contract along with their advanced funding. And we think that this is going to be another tool in our tool bag. As I said, when we sit down and negotiate with park owners through FMHA, we don't have a lot of leverage. I think we have a legal fund sitting over there with $500,000 in it, and we show we don't have a reluctance to utilize that, to use that fund. It's going to give us a little bit more leverage at the negotiating table, and we might have to prove that we're going to use the fund to do that. But I think the fund is going to give us something that we haven't had in a while, and that is some leverage. But the bottom line is we need more members at FMO. For $25 a year, you're getting a lobbyist in Tallahassee. You're getting our monthly magazine. We've saved you. We've saved you in the past 5 years sales tax on your lot rentals, because the governor wanted to do that. Our legislators wanted to do that. We pushed back on that. The reason we have a relocation corporation and a relocation fund is because of FMO. And I just happen to be on the board of that as well, and so is Richard. And we're working to see if we can't make more money available to people who are in that kind of a situation. We don't know why it's so low, other than it was created many years ago and it really hasn't changed that much. So Richard and I and one other FMO member, our vice president, is on the board of the Relo committee, and we're trying to push them along to see if we can't make more money available. The whole reason the relocation fund is there is because of the FMO many years ago. It's like the tie-down program. Every year we have to fight the legislator to keep that money in the budget, and we were successful again for 2016. The money's still in the budget. Our 2016 legislation has been passed, and we're waiting for the governor to sign it. And probably the centerpiece of that is really the piece where we wanted to put more pressure on DPPR. And we're still not happy, as you are, with the response to DPPR. We're looking for other ways to put pressure on them. We depend on them to be the policeman, sometimes the judge, in our cases when we bring complaints to them, and it's just not happening. And it's not happening to our satisfaction. So we're continuing to work on all the phases of this, trying to protect and improve our lifestyle. You didn't cut anybody off, folks. Thank you.
Are there any quick questions about the legal fund or anything else? We can ask, he'll be here, so you can talk, right? Oh, excuse me, wait.
No.
Oh, wait.
I just wanted to ask you, 723, when you have a dispute with the park owner, if he has violated your rental agreement, which, to my opinion, there's his name on it and mine. And I was told, oh, you have to go through the HOA and you have to have a committee of 5 people go sit down and talk to him about this. And I said, no, I don't. I only see 2 names on this paper, mine and his. And I proceeded on my own. And when you have a dispute with ELS, I feel, if it's a direct violation of the paper you signed and they signed, then you certainly have a right to stand up for what you think is correct.
Yes, you do. One of the things that DPPR says, and they're right in this instance, is that you have a couple different documents. You have your prospectus, you get that. Your prospectus basically tells your rights and obligations living in that park. It also should have how your rent is going to be increased over the years, whether it's CPI or in my case it's CPI plus, or if CPI doesn't move, we still get a 3%. And you are entitled to have more than one prospectus within the park. I want to make that clear too. They can get a prospectus approved. However, it's not retroactive. It's only given out from the date it's approved to new homeowners that buy new homes in that park. That's what happened to me. Our park was wiped out in Hurricane Charlie in 2004, so every home in there in 2005 or newer. But there are some that didn't get affected by the hurricane, and they still have an old prospectus, and they didn't get a rent increase this year because theirs says CPI only, and CPI didn't move. It didn't move to the positive side anyway. They didn't get a reduction, which is great to hear. Some of you people got a reduction. They didn't get a reduction, but they didn't move either. In my case, my prospectus says that CPI doesn't move. They can raise it to the maximum of 3%, which is what they did to compensate for all the people who didn't get any rate. But there is all they have to do, and the unfortunate thing, this is one thing we want to work on for 2017. All they have to do is send a new prospectus to DVPR, and they just rubber stamp it, and then they have to tell us in 90 days that it's been approved. We feel we want to be part of the process. We want to know when they submit a new prospectus. We feel that it's our right to be told about that so we can comment on it. Same way with rules and regulations. They can't be changed unless they submit the new rules and regulations to the DVPR, and they rubber stamp them. Basically, even the prospectus, they don't go back and look at the old prospectus. All they do is look at the new one and make sure it conforms to the lower plate, and then they rubber stamp it. Same way with rules and regulations. They passed, ELS got a rules and regulations change going back a few years. The rule number 15, which says the park manager could change any other rule if he has the mind to make an exception to any of the other rules, which is kind of ridiculous. But those are the kind of things that we have to deal with, and those are the kind of things that we want to fight. And if we can't do it through legislation, we're hoping that the legal fund is going to give us another way to affect change.
On the legal fund, for those of us that already retained the lawyer, who is Lee J. Collins, same as FMO, how is that going to be affected if we pay our $1,000 or the $500? Do we still need that retainer? Or?
Yeah, it has nothing to do with the attorney that you hire or the attorney that you might have on retainer. All this is if you bring in a legal action, this is going to, you submit an application to the committee, and if it's something that we feel we should support, then we will give you all the money, grant you all the money you need to pay that attorney's fees for that action. Okay? But it has nothing to do with you hiring or keeping an attorney. And Mr. Colling is going to represent you as an HOA. He's not going to represent FMO in that case. And as I said earlier, FMO is not going to be a party to any of these legal actions. It's between the HOA and whoever they're bringing the action against. All we're doing is putting up the grant money to write the check so you can write the checks to your attorney.
Does the HOA pick the attorney?
Sure. Yeah, the HOA.
What about a list of attorneys?
Yeah. HOA picks their own attorney, and if you want to do that before we get the list out, make sure that they practice 723 and they understand what 723 is. And a lot of times, if it's a really good attorney, even if they haven't tried a 723 case, they'll come up to speed on it pretty quickly. But be careful, because there are people that say I think there was some story in the paper recently, I guess it was, that an attorney wanted to drop out of the case after a year. And, that's crazy. Unless people stop paying, then he has an excuse. But not to give up the case just because he doesn't feel like it's something he wants to do any longer. I think that's right. That's why it's important. And that's why we want to put together a list of attorneys that we've talked to, and they understand what you're looking for, and that's what we want to make as part of the program.
Round of applause.